The revised draft regulation for medical marijuana facilities generally. The Missouri Department of Health and Senior Services released a number of revised draft regulations for medical marijuana. Now, I'm not going to go into completely review the entire draft rule, as I've already done so in a previous video. What we're going to focus on today is the changes and important parts of the revised rule. This rule is much larger than most, and we're still not going to cover it word for word.
My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law.
This video will focus on the revised draft rule for medical marijuana facilities generally, 19 CSR 30-95.040. This rule is the main guideline for marijuana facilities. It includes common language for all the facility types and licensing. Each facility type, cultivation, dispensary, infused product, testing, and transportation, all have their own regulation in addition to this rule. The rule is clear that there are limited windows of application for licensing. If you do not apply before this first window closes, you will have to wait until the next application window, which will be published at least 6 months before opening of that application period. So get your applications right before submitting, because the requirements here are strict. Paragraph 6, 6 months prior to the beginning of that time period, applications will be considered complete if they include all the information required for the application by this rule and by 19 CSR 30-95.025 paragraph 4. The department will notify an applicant if the application is incomplete and will specify in that notification what information is missing. Applicants will be given 7 days to provide missing information. Look, 7 days is not a lot of time to get the notice and respond, especially if they mail it. You know, there are quite a few application needs that will take more than a month to get. You need to start working on that now. If you're missing any of those, your application is likely going to fail. And look, seriously, if you are looking at spending hundreds of thousands to millions of dollars opening your marijuana facility, don't cheap out on licensing. Hire licensing help. Expect the cost for a team to help with your license to run in the 5 figures. $25,000, $50,000, even up to $100,000 if necessary. Don't be afraid to spend it. Also, remember that just getting your application in and initial approval does not mean that you're going to get that license. You still have to complete your build out, hire and train your staff, and pass the commencement inspection. Section 1D, the issuance of a facility license or certification does not authorize a facility to begin cultivating, manufacturing, dispensing, testing, or transporting medical marijuana. A facility will be granted final approval to operate upon passing a commencement inspection. Now this is looking like March or April of 2020 at the earliest to get a facility running. Now let's take a moment and talk about the ways that your license will be able to be revoked. Section 1F, licenses and certification for facilities may be suspended, denied, or revoked. 1. If a facility provides false or misleading information in an application, its application may be denied, or if the information is later discovered to have been false or misleading, its license or certification may be revoked. Plans, assurances, and projections offered in the answers to 19 CSR 30-95.025 subsection 4, evaluation criteria, questions may be considered false or misleading if, upon application for license renewal, the department determines the facility has not made a reasonable effort to implement or follow through on these plans, assurances, or projections. Note, if you tell the department that you plan to do something and you don't do it, you may lose your license. Even if failing to do that something is not a violation of the regulations. Paragraph 2. If a facility violates any provision of this chapter or fails to comply with a corrective action plan, its license or certification may be suspended or revoked. Folks, the department tells you you got to do something, or you have to fix something and you don't, you might lose your license. Paragraph 3. If an applicant fails to provide a complete application within 7 days of being notified that an application is incomplete, the license or certification for which the applicant is applying will be denied. We covered this already. Get your apps in. Get help if you need it. Paragraph 4. If a facility is granted a license or certification but has not passed a commencement inspection within 1 year of the department issuing the license or certification, the license or certification may be revoked. And let's face it, you will also be hemorrhaging cash. You got to get this in, get it done, and get your construction ready to go. Paragraph 5. If a facility fails to comply with a department order to immediately suspend all or part of its operations, the license or certification shall be revoked. You gotta shut down if they tell you to shut down. 6. If an application does not meet the minimum standards for licenses and certifications pursuant to 19 CSR 30-95.025 subsection 4, the license or certification for which the applicant is denying or is applying will be denied. 7. If a facility uses combustible gases or other dangerous materials to extract resins from marijuana without a manufacturing facility license, the facility's license may be suspended for up to 1 year. 8. If a facility or facility employee fails to comply with seed-to-sale tracking requirements or intentionally misuses or falsifies seed-to-sale tracking date, the facility's license may be revoked. Pay close attention, number 8. Mistakes here can be costly. And don't forget to plan for your annual fees after you get your license. Section H. The department shall charge an application or renewal fee for a facility license or certification, and also an annual fee once a license or certification is granted. The first annual fee will be due 30 days after a license or certification is issued, and shall be due annually on that same date, as long as the facility's license or certification remains valid. The department shall publish the current fees, including current adjustments, on its website. The amount of fees due for each facility will be the amount that is effective as of that facility's due date. You realize, of course, that these businesses are intended to be fee-generating entities. Profit be damned. Section 2 of this regulation has the application requirements. If you are applying for a license, start reading it and building checklists to make sure that you don't miss anything. Remember, 7 days for screw-ups. You don't have a lot of time. This reg also contains the same constitutionally mandated unconstitutional section B3 regarding ownership being restricted to majority Missouri resident owned. A lawsuit challenging this could derail medical marijuana in Missouri for a year or more, as all potential license scoring would be suspect. One of the big things that potential licensees must be aware of is Section 3C. Quote, all licensed or certified cultivation, dispensary, manufacturing, testing, and transportation facilities must seek and obtain the department's approval through a department-provided format before they may 1. Assign, sell, give, lease, sublicense, or otherwise transfer its license to any other entity, including a parent company or a subsidiary. Such requests will be accepted beginning January 1st, 2021. You buys your ticket, you takes your ride. There are going to be no transfers or secondary license market before 2021. Think about that. Make any changes to the ownership interest, organizational structure, or financing arrangements of the facility. Such requests will be accepted beginning January 1st, 2021. This is critical. You have to make sure that you have all of your financing or cash in hand to operate through 2021. You will not be able to borrow money, bring on additional investors, or even alter the corporate structure before 2021, and then only with the approval of the department. No word yet about what will be required for that approval, but I bet it is a fee. Paragraph 3. Materially deviate from proposed physical design or make material changes to the current physical design of the facility. Look, this is the kind of thing that lawyers fight about all the time. What is a material change? And what is substantial compliance? You're going to need a lawyer if you're dealing with that. Paragraph 4. Combine licensed facilities owned by a single entity at a single location. Such requests will be accepted after the facilities at issue have been granted a license. Or 5. Begin construction on a warehouse sited at a location other than the approved location of the facility. Such requests will be accepted after the facility at issue has been granted a license. Look, this reg goes on to discuss security, label requirements, more. I'm not going to get into all that here. Frankly, if you're seeking a license, you need to read, reread, and reread this regulation. It must be taken in conjunction with the other regulations concerning your specific type of facility. Now, please like, subscribe, and hit the alert bell. We have a lot of videos coming on these. There's a lot more videos coming. They dropped a number of updates, so plan on a video a day for at least the next week or more. Thank you very much, and we'll see you soon.